Can everyone hear me clearly? All right. Well, my name is Stephen Johnston, and on behalf of the Department of Culture, we would like to welcome you to the 16th Annual Robinson Packwood Memorial Lecture titled Law to Legacy, Unravelling the Narrative, a Critical Legal Study of the Institutionalization of Slavery in Bermuda. Before we begin, we would like to acknowledge the presence of His Excellency, the Governor of Bermuda, Mr. Andrew Murdoch. Welcome. We'd also like to welcome the Minister of Tourism and Transport, Culture and Sport, the Honorable Owen Darrell, JP MP, who will now deliver opening remarks.
Good evening, everyone. It's my honor to be here with you at the 16th Annual Robinson Packwood Memorial Lecture. This annual gathering stands as a tribute to two of Bermuda's most respected historians, men who dedicated their lives to preserving our collective memory and ensuring that the truths of our past are never forgotten. This evening, we are privileged to be joined by our distinguished guest speaker, Ms. Cheryl Packwood. Many of you will know that Ms. Packwood is not only a scholar of international standing, but also a proud descendant of the Packwood family. Tonight, she returns home to share with us research that strikes at the very heart of Bermuda's legal and social history. The title of her lecture, Law to Legacy, Unravelling the Narrative, a Critical Legal Study of the Institutionalization of Slavery in Bermuda, is both an invitation and a challenge. It invites us to listen with open minds to an honest exploration of how law was used as a tool to strip away the humanity of entire people. And it challenges us to see clearly the legacy that is such laws have left behind. As part of our emancipation observances, we're reminded of this year's theme, Time Tells Our Truth, a Legacy of Freedom. It is a timely and powerful reminder that truth is not always comfortable, but it is always necessary. Ms. Packwood's lecture will take us back to some of Bermuda's earliest statutes, including the Act of 1923 that codified chattel slavery, more than 40 years before similar laws were passed in other colonies, and the beginning of institutionalization of slavery. Understanding the legal roots of injustice helps us to recognize how the echoes of those laws still shape our society today. The government remains committed to supporting historical education, not simply as acts of remembrance, but as essential steps towards building a future grounded in equity, dignity, and inclusion. The work of uncovering and speaking the truth as a collective responsibility, and tonight is one more step in that ongoing journey. I wish to thank the Department of Culture for organizing this important lecture as part of our emancipation celebrations. And I extend my gratitude to Ms. Packwood for bringing this crucial narrative home, for doing the painstaking work of research, and for having the courage to share it with us today. I encourage each of you to listen deeply this evening, to reflect honestly on what you hear, and consider how we might each play a role in shaping a legacy worthy of future generations. Thank you.
Thank you, Minister. Now, to honor the memory of the man whose legacy we continue to celebrate, we invite a member of the Packwood family, Mr. Amoti Naibungo, to share a short reading of Mr. Cyril Packwood's biography.
Thank you, sir. Good evening, good evening, good evening. How are you? I see a familiar face. Okay, I see a couple of familiar faces. Okay, so I got this assignment from my younger cousin, Cheryl, who has constantly raised the bar for her older cousin when she didn't even know it. I'm not going to go into her academic record because I think most of you are aware of it. But she used to say, well, she tells me now that I used to tease her when we were young. I don't remember that. But anyway, without further ado, let's get into my Uncle Cyril. Cyril Outbridge Packwood was my elder cousin, referred to as uncle, and godfather. He was born in Bermuda on November 22nd, 1930, to Cyril and Gladys Packwood. My great uncle Cheryl Sr., loved to tell the story of how his son was the first successful cesarean birth in Bermuda. I guess for some, that would have such a remarkable life and offer so much that was remarkable, it really was only fitting that he make the entry onto planet Earth in such a manner. Cyril grew up as an only child in Wellington, St. George's, and attended East End Primary, Temperance Hall, and Berkeley Institute. He left Bermuda at the age of 15 to finish high school in the United States. He earned his bachelor's degree in history from Fisk University. He earned Fisk University in Nashville, Tennessee in 1953, and a Master's of Science degree in Library Science from Western Reserve University in Cleveland, Ohio. He later received a second master's degree in history from the city of New York. When Cheryl first went off to school, his intention was to study chemistry and become a dentist. At Fisk, he met Miss Anna Bontemps, the famous writer and historian from the Harlem Renaissance, and also the chief librarian at Fisk. That relationship would change and shape the course of his life, of which would end up giving so much back to the community from which he came. He worked in the New York Public Library system from 1957 to 1968, where he was the head librarian at the County Cullen Library in Harlem, and then at the Borough of Manhattan Community College, where he was the chief librarian. It was at BMCC that he started to mentor me. BMCC, Borough of Manhattan Community College, was my first stop before I transferred and went to Tuskegee University. He remained, when the position of chief librarian at Bermuda Public Libraries opened up in 1985, he came home. He remained at the Bermuda Public Library until his retirement in 1993. Uncle Cyril wrote 2 books on Bermuda's history and numerous articles which were published. Chained on the Rock was his first published in 1975, and to this day is known as the foremost treatise on slavery in Bermuda. He also published in 1977, Detour Bermuda, Destination U.S. House of Representatives, The Life of Joseph Rainey. An unpublished manuscript of the life of the Reverend Edward Fraser was published in 2012 with the 3rd edition of Chained on the Rock by the Bermuda National Museum, with special thanks to Dr. Edward Harris. He had many different interests. He fell in love with the African continent on his first trip to the continent in 1974. He ended up returning every year, and sometimes 2 and 3 times a year for the rest of his life. He would share his adventures with us through photographers and African art. In my younger years, his love of railroads, American and European, was shared interest between us. He also loved boats and served on the Bermuda Government Committee for Marine and Ports. He was a Rotarian. He worked with the Bermuda Aquarium and Zoological Societies, and was a docent at the National Art Gallery. He was a trustee of the Bermuda Maritime Museum and Dockyard. Uncle Cyril passed in 1998 after a brief illness, survived at the time by his loving wife, Dorothy Isabel Packwood, who herself was an elegant testimony to his life. Before he died, he and I had many conversations about life and my vocation as a helicopter pilot. As my godfather and elder, he was supportive, even if he didn't agree with what I was doing, and I thanked him for that. Always asking, how was I doing, and saying, you know, all you have to do is ask. He was that kind of godfather to me, and I believe he was that kind of friend to all of us here in the room. Cheryl Packwood is the only child of Cyril and Dorothy Packwood. Uncle Cyril had a smile and a kind word for everyone. He lived a full life, a wonderful life, and loved the people he met during his life. He set a very high bar in how he lived. I miss him and the conversations, but his spirit lives on in all of us. Thank you very much.
We now would like to welcome poet, author, and my cousin, Matthew Johnston to share his piece, We Must Water What Has Been Sown.
Good evening, everybody. I'm grateful to be able to share with you today. As Stephen mentioned, the poem is called We Must Water What Has Been Sown. The deep ruby of blood has spread out like constellations, scattered across canvas of sky to mimic displacement, to share stories, to map untold journeys. Veins braid a city of roots, outstretched fingers seated in soil, thirsty for nourishment, endlessly searching for the unknown, flush with shimmering lineage intended to be buried over and over again, but refusing. Veins sprawl themselves in sacred flesh, throbbing with echoed heartbeats syncopated enough to shift limbs and move feet. Hips swing and we mirror freedom in a way that feels like eye of storm, like missing piece, like finding home. Arms are branches, extended to grasp sun, as feet rooted in earth twist memory into soil. Memory is remembering your blood. It is the everlasting deep ruby that refuses to surrender. It is holding on to the traditions. It is never forgetting the bruise. It is never forgetting the flowers that bloom at feet. It is being unafraid to build on the shoulders of giants. It is nurturing and sprouting like never before. We have known soil just as well as we have known sky. We have whispered worries to earthworms. We have snatched breaths from air and nestled them in chests for safekeeping. We have refused to die. Whether it be blood, sweat, or fire, we are here. Roots planted in earth, branches in communion with sky, blood carrying heritage that leaves mouth stained sweet with freedom's nectar. Sometimes, when draped in such sun-quenched armor, inheriting freedom feels like a gift. No matter if wrists still feel shackles sting. It is known that we must prune and harvest and carry. It is known that the work is never finished. Thank you.
We are now honored to have Ms. Cheryl Pierman introduce her late father, Dr. Kenneth E. Robinson, and share his contributions with us.
Good evening, everyone. Hello, Cheryl. Hi. It's a pleasure to be here. 16 years ago, in 2009, the Department of Community and Cultural Affairs launched the inaugural Robinson Packwood Historical Lecture. On that occasion, at the Hamilton Dinghy Club, Drs. Clarence Maxwell and Radal Tankard were the guest speakers. They aptly demonstrated that they had positioned themselves to build on the foundation laid by two Bermudian premier historians, my father, Dr. Kenneth E. Robinson, and Cheryl's father, Cheryl Packwood. Tonight is the first for both daughters share the same stage. Dr. Kenneth E. Robinson, OBE, BSc, PGCE, Masters of Education, and Doctorate of Education. My father was born in 1911, the only child of Olivia and Hilton Robinson, residents of North Village, Hamburg. His secondary education was completed at the Berkeley Institute and Excelsior Secondary School. In 1931, he entered University College London in the UK on Bermuda's Technical Scholarship for Boys of Color. In 1936, he graduated with a BSc honors degree. While his intention was to have read for law, his very early university experiences changed his trajectory. He felt that his island education had not prepared him adequately for tertiary level, and his knowledge of Bermuda's history left much to be desired. He changed course. He would right the wrongs that had ill-prepared him as a university student. He would obtain superior educational credentials and training. He would return to Bermuda and be a change agent. In 1952, he obtained his doctorate in education and administration from Harvard University, Massachusetts, and was the first Bermudian to attain a PhD designation. He was now more than adequately equipped to take on the status quo, fight for change, and implement measures which would bring education into the 20th century. As president of the Bermuda Union of Teachers, he became a force to be reckoned with, to the extent that Front Street sent him a message. Tell that chap Robinson that when he tires of bowling, he can come into the shade. This was a cricket reference. My father taught at the Central School, Victor Scott, Berkeley Institute, introducing the RSA examinations. He was principal at Sands Secondary School, as was his founding principal at Harrington Sound School and Francis Patton School. He would enter the Department of Education as supervisor of schools and eventually become chief education officer in 1970. He retired in 1976. Throughout his career in education, my father was arduously researching to create more relevant Bermudian-centered educational materials. As a principal, husband, and family man, he spent countless after-hours researching our history from primary sources and personal interviews. His self-assigned task was to right the wrongs he had experienced as a student in the United Kingdom. When my father wrote his signature work, Heritage, the subtext read, including an account of Bermudian builders, pilots, and petitioners of the early post-abolition period, 1834 to 1859. His language was deliberate and specific, and his purpose uncompromising. In one of our father-daughter conversations, he was erudite in stating emphatically that he was writing us, that is, people of color, into the history of Bermuda, an almost revolutionary position to take in the 1950s and 60s. My father and Cheryl Packwood had a mutual respect for one another, as you can observe from the photograph that I made available to the Department of Community and Cultural Affairs some years ago. The moment was a fortunate happenstance, and I see that there are additional photographs. I don't know where they got them, but I'll have to find out. Chained on the Rock is our definitive pre-emancipation study. Heritage, however, examines and addresses the first 25-year span post-emancipation in 1834. revealing that we were consequential people. Had he not revealed and documented this for posterity, our forebears' participation and contribution to this island would have been lost to time. In January 1976, Mr. Packwood autographed my father's copy of Chained on the Rock, thus, to Dr. Kenneth Robinson, in appreciation for all your help and valuable suggestions in making this book possible. My father's journey and dedication to his self-assigned task could not have been as smooth or as productive without the support, indulgence, and understanding of his wife, my mother, Rosalind Taylor Robinson, herself a principal and much revered educator. At age 67 and after 2 debilitating strokes, my father succumbed on Friday, October the 13th, 1978. Much of his research and work was left unfinished. I realize now how young he actually was. Heritage was published posthumously by my mother, who had made a promise to her husband that she would guarantee that his life's work would be published. Dr. Kenneth E. Robinson's legacy is honored and protected by his daughter Shirley and her family, Roderick Scott Pearman and Michael K.R. Pearman, his granddaughters Robin Villana and Anya Leash Pearman, as well as the family of his late son, Kenneth Edward Robinson. Thank you.
And now, the moment that you've been waiting for. But before Ms. Packwood takes the stage, I'll briefly share her biography and highlight the incredible work she has done. Cheryl Packwood was born and raised in New York City to Cyril and Dorothy Packwood, both immigrants of Bermuda and Caribbean diaspora. She grew up in a home of teachers and librarians who emphasized education and service. Her father was a historian who authored several books and scholarly articles. Her extended family included the dynamic community of artists, academics, free thinkers living in New York City in the 1960s and 1970s. Ms. Packwood attended the Bronx High School of Science, where she discovered her desire to write and teach. She attended Yale University and graduated cum laude with a BA in history and a certificate from the Honors Teacher Preparation Program. She taught social studies, integrated math, and geometry in the New York public school system. She continued to Harvard Law School and with the intention of teaching. She was selected to join the Board of Student Advisors, where she taught the required legal research and writing program for the first year law students. She received honors on her third year paper under the tutelage of Judge A. Leon Higginbotham. She recently received her LLM from Boston University School of Law in Banking and Finance in May 2023. Ms. Packwood practiced law at Sherman and Sterling in New York in the litigation department. There, she cemented the legal writing and advocacy skills that she would use throughout her career. She moved to Abidjan, Côte d'Ivoire, where she developed an international practice for a major law firm. In that practice, she was required to communicate complex notions of contract law, corporations, employment law, oil and gas law, energy, telecommunications, finance, and litigation to Ivorian, Australian, Japanese, British, South African, American, and clients of many other nations. Basic notions of law needed to be made understandable to lawyers of very different legal traditions. She was legal counsel to Her Majesty the Queen of England, the United States government, and the government of South Africa and Côte d'Ivoire. Ms. Packwood has extensive international experience. She was the overseas representative for Bermuda to the US and the CEO Deputy Chair of Business Bermuda, where she developed business globally for Bermuda. She was the General Manager of Digicel Bermuda and Director of Legal Enforcement and International Affairs at the Bermuda Monetary Authority. As the first woman to head of a telephone company in Africa, she pioneered GSM Cellular in Africa. Most recently, she served as a visiting assistant professor of law at Albany Law School in New York State, where she taught public international law and international business transactions. Ms. Packwood is an experienced public speaker and has authored many articles for professional magazines, journals, and reviews, covering topics in international business, finance, law, and history. She is a licensed attorney of the New York and Washington, D.C. bars. She is fluent in English and French and has an excellent command of Spanish. She is a mother of 3 wonderful adult sons. And now, I'd like to welcome Ms. Cheryl Packwood.
Thank you so much for that. Now I have to live up to that. Good evening. His Excellency the Governor, Mr. Andrew Murdoch, Minister Honorable Owen Dow, Minister Kim Wilkins, you're there somewhere, I saw you come in. There you are. Honored guests, family, and friends, and my fellow speaking mate, Shirley. I would like to thank the Ministry of Tourism and Transport, Culture and Sport for inviting me to speak at the 16th Annual Memorial Lecture Series, named after 2 great men, historians, giants, husbands, fathers, and grandfathers, one of whom was my father. I want to say that it is truly an honor to speak to you tonight. I have spoken all over the world, but when your island home gives you the privilege of speaking, one is truly humbled and honored. Thank you. How can slaves be happy when they have the halter around their neck and the whip upon their back, and are disgraced and thought no more of than beasts, and are separated from their mothers and husbands and children and sisters, just as cattle are sold and separated? Mary Prince, daughter of our island, slave, abolitionist, hero, and so much more. The title of my lecture is rather long and perhaps complicated. I had to decipher it too. Law to Legacy, Unravelling the Narrative, a critical legal study of the institutionalization of slavery in Bermuda. I was thinking of legacy as we just finished another cup match. My team didn't quite win yet again next year. But cup match is so much more important than a 2-day match of cricket. It is all about community and legacy, with its roots going back to emancipation on 1st of August, 1834, and the Friendly Society's picnics and games. It is about speaking truth to power. When the Black population in Bermuda put down tools every year and came together in community to celebrate emancipation. It is also about outrageous outfits paraded during these 2 days, which stood in contrast to basic uniforms worn in everyday life. I want to diverge briefly, although maybe I've already been diverging, but anyway, and say that I grew up on all of this history. Whether it was slavery in Bermuda, my father's discussions, arguments with Terry Tucker, the story of the Sea Venture, cup match cricket teams, walking my grandfather to the St. George's Cricket Club every Wednesday evening before the start of cup match to check that everything was in order. And he did this long after no longer being vice president of the club. It was tradition. So whether it was all of these little events and stories, I have understood that history is made up of all of our little and big stories. My father would spend his summers at the Bermuda archives, researching first his master's thesis and then his classic work, Chained on the Rock, when the archives was originally located in the old Bermuda Library building in Parleville Park. I know you old people like me remember that. Oh, the stories that can be told, including ghost stories. I would be in and out to find my father. So when I sat down to do my research years later, I felt quite at home. Dinner conversation centered around Sally Bassett, or Fleeper, the young woman who had held on to a crumpled piece of paper, granting her her freedom. I still have the manuscript of my father's novel based on this very case. It needs to be finalized. These stories are ingrained in my head, in my heart, and in my soul. They too are my legacy, and they are your legacy too. So what is critical legal studies and the institutionalization of slavery? What is our legacy as we come out of another year of cup match and the history that it represents? First, critical legal studies is a theory that laws are not neutral or objective. They are created by men, and now women, to maintain and reinforce the existing power structures. When I set about looking at the institutionalization of slavery, I studied the laws passed, why they were created, and the ultimate purpose they were trying to achieve. I looked at case law, court decisions, and proclamations by Bermuda's early governors, not you, to see why and how an institution was put in place. You have heard a lot about critical race theory, I'm sure. It came out of the same group of professors in the 1970s and 80s. Critical race theory, more specifically, looks at race, law, power, and how it is entrenched in our legal systems. Professors Derek Bell and Duncan Kennedy at Harvard Law School were both leaders in critical legal studies. Justice Alien Higginbotham from the U.S. Third Circuit Court of Appeals, under whom I wrote the original paper, was very much an adherent to these theories. And I was lucky to learn from all three of them. That's how old I am. To see how slavery came to be is a process of examining the laws and analyzing how a community can come to enslave a population, or perhaps more accurately, maintain legally the enslavement of a race-based population. So you have to start at the beginning. It is always the beginning that is so fascinating in the end. All of us legal beagles and historians alike have operated under the assumption that the first black people who entered Bermuda and the mainland of the United States, North America, came as indentured servants. We make this assertion because there was no structure in place to support slavery. Indeed, slavery as an institution requires laws which support it. And so we look to see how a structure is put in place that can support such an institution. I have always silently questioned this supposition. The first black person was specifically brought into Bermuda from the Caribbean in 1616 to dive for pearls. He did not come on his own volition. He was procured, quote unquote. He was bought. Slavery already existed in the Americas. This man was most likely a slave. He arrived in Bermuda, a land with no law or structure to enforce his enslavement. But I would argue that he was a slave nonetheless, despite no legal structure. Nevertheless, all us good legal scholars want a structure, a system of laws, an institution to ensure that those who are slaves can stay slaves. Indeed, as we see the early colony evolve, those colonists did exactly that. they set about putting in place a legal structure to support what comes to be black chattel slavery. We do not have to wait too long for the case of Simon to come along in 1617. And every time I read over the case from the Court of Assizes, I've been trying to figure out whether it's Assize or Assize all day, I think of something new. Simon was a black man. He was accused and found guilty of having sex with a child. He was sentenced to be a slave to the colony at the governor's pleasure. His fellow trial mate, so to speak, Nicholas Gabriel, was sentenced to death by hanging for mutiny and rebellion, which sentence was commuted to slavery to the colony pending his good behavior. These cases are fascinating for a variety of reasons. These men committed very different crimes, but the descriptions in the records provide clues as to the early colonists' understanding of the community and society, and yes, race and a person's place in that society. Nicholas Gabriel was in all likelihood a white man. The use of his surname and the labeling of his profession, laborer, were distinctions granted to white persons in the colonial records and denied almost categorically to black people. Also, he was probably not a servant to anyone. Nicholas Gabriel did not have the label of being a servant to any master placed upon him. Furthermore, Nicholas came from Pembroke Parish. He had a home and a location. Black folks almost always were located at the place of their master's residence if they were described as coming from anywhere. In contrast, Simon had no surname and came with the descriptor Negro. He had no profession and no place of residence. Indeed, was this the case of the beginning of determining that Bermuda would never represent a home to black people? And more to come on this issue. Interestingly, 9 years later, in 1626, the court failed to punish Henry Simons, he's got a last name, despite a finding of guilt for the criminal assault of an 8-year-old girl. There were no racial identifiers, and last names were provided for both Old Henry and the little girl. The court made no racial contrast and issued no punishment. Frankly, we can discuss these cases ad nauseum. Nicholas Gabriel's enslavement would end with his good behavior, while Simon was the black man would be enslaved indefinitely. Yet the law had yet to speak. Simon could have remained a slave for the duration of his life, and then what would have been the status of his children? Would they too be slaves to the colony? Would they be servants automatically, or would they be free persons? Would the eventual status of the mother of Simon's offspring be the determining factor? The colonists are going to answer that, obviously. Oh, good. The judiciary, governor, and legislature would begin to answer these questions with the Act of 1623, an act to restrain the insolencies of Negroes. This act is the first of firsts. Bermuda has the distinction of being the first among its peers to pass legislation in the British Empire concerning black people as early as 1623. And I posit that this act is the beginning of the institutionalization of black slavery in Bermuda and indeed in the British Empire. I know my article is dense, for those of you who have tried to get through it. It is a legal academic article, and it can be pedantic with all the footnotes and rules of citation necessary for publication in law reviews. I do, however, want to focus on this act. We all cite it we being historians and people like me. But we miss the very point of slavery being legislated, recognized, real, as early as 1623 in the British colonies. As I discussed in my article, in this single legislative act, the House of Assembly stripped blacks of their rights to go out freely at night, carry weapons, and trade and sell commodities. These major activities necessary to the autonomy of an individual were systematically taken away from the black person in this legislation. In effect, this statute managed to make the black man and woman dependent on the white population for physical protection, economic well-being, and social contacts. Without a white master, a black person did not have the power to self-determine his or her life by making the decisions of a self-autonomous individual. Thus, how could a black person survive in the country without the protection of an Englishman? Finally, and most importantly, within the statute, the concept of ownership of blacks was codified with the language master or owner of such Negro. Black people were owned by white persons, and this 1623 Act establishes and codifies into law a practice that was already, in fact, in existence. While Simon had been enslaved in 1617 to work for the benefit of the colony, and the colonial government became, in effect, his owner, there was no formalized system of laws to support the enslavement of a group of people. With this statute of 1623, which served to disempower blacks, the idea that blacks could be owned by other human beings appeared and was codified. Accordingly, the act stipulated that if any Negro shall hereafter wear any weapon in the daytime or known to walk abroad at any undue hour in the nighttime, ... that then the master or owner of such Negro shall from time to time make full recompense to the person. Now I know this is hard to read. Think about if it was in that old script. So not only do you have almost a different language, but doing the research in the old handwriting, it's hard. I have to emphasize that the legislature used the word owner in the text of this act. As early as 1623, blacks had owners, and the word owner, its usage, is powerful. When one person is the owner of another person, this is slavery. What else can it be? And if I went to court to litigate this, I swear I'd win. In 1623, the English colonists were well on their way to the institutionalization of black slavery in Bermuda, for those black persons were already owned by some of the settlers. Interestingly, it wasn't until 1639, 16 years later, after our Bermuda 1623 Act to restrain the insolencies of Negroes, that we find the first mention of black people in Virginia legislation, with an act to restrict access to arms and ammunition. They go about it the same way. With the 1623 Act, the institution of slavery became a matter of fine-tuning. The act effectively served its purpose until the 1656 slave rebellion. 9 men were tried and found guilty. 2 of them were executed. The governor issued a proclamation 4 days following the trial on November 6, 1656, reiterating the prohibitions of our 1623 Act regarding trade, going out freely at night, and carrying weapons. He added some new measures. A black person found wandering about without a pass, day or night, could be summarily killed and one white person's judgment was sufficient for the killing of a black person. This prescription was eventually reduced to whipping in 1660 by the governor. And I believe that this is because, after all, a slave was property and worth money. As an additional measure, the governor also prohibited private meetings of black slaves in his proclamation. You know, if they meet, they're going to foment a rebellion and poof. What is most fascinating about this proclamation of 1656 is that the governor ordered all free black folks to leave the island. Many issues are going on here, including the idea that free black people living on the island contradicted the very notion of black enslavement. And of course, there was the very fear that a black population would incite further rebellions. Throughout slavery, we see the continuous attempts by the English colonists to make free black people leave the island. In 1663, the legislature enacted this prescription into law. Bermuda could no longer be home to black people. If you remember, I foreshadowed this concept with the case of Simon in 1617, when he didn't seem to have a place of abode, as opposed to Nicholas Gabriel, who came from Pembroke Parish. Requiring free black people to leave Bermuda was reiterated in cases and legislation going forward, including the Acts of 1687 and 1730, as well as the case of Black Kate in 1672. It is interesting that this concept of a land not being home to black people was a truism throughout the colonies in North America. And we see this idea being revisited with US President Trump's attempt to get rid of birthright citizenship, which was granted to free blacks by the 14th Amendment of the US Constitution, to make them citizens and America their home at the time of emancipation. And as a note, birthright citizenship was extended to all children born in the US by the US Supreme Court decision in US versus Wong Kim Ark in 1898. The colonists tried all forms of punishments to complete the process of black dehumanization, from whippings and execution to fines on their masters. Apparently, the colonists overreached the bounds of acceptable sanctions when, in 1704, the House of Assembly passed yet another act to prevent the insolencies of Negroes and other slaves, for the British Crown disallowed this statute. The House of Assembly had determined that all black men would be castrated for violating that act. This statute demonstrated the extreme violations of human dignity to which the colonists resorted in order to complete the process of black subjugation. And indeed, slavery became more than ownership. It was a loss of being human in the eyes of the law and the community. The black slave was no more than a chair, to quote Chief Justice Taney in the famous Dred Scott decision of the US Supreme Court of 1857. In 1730, the House of Assembly would devalue completely black life when it passed an act for the security of the subject to prevent the forfeiture of life and estate upon killing a Negro or other slave. The act decriminalized the killing of a black person, a similar provision of which had appeared earlier in the gubernatorial proclamation of 1656, if you remember, was now codified in the laws of the colony. It was no longer a crime to kill a black person or other persons of color on the island. The willful killing of a black person only incurred a fine. Interestingly, colonial powers in England found this statute acceptable, but refused to permit the castration statute of 1704. Apparently, no cases of record arose under this statute before it was repealed in July of 1789. No such instances had occurred, but I would ask the question, if it was no longer a crime to kill a black person, then there would be no need to prosecute an individual and there would be no official records. A fine for the willful killing of a black person was appropriate where that person is nothing more than property. This is chattel slavery at its core. Blacks would not be allowed the rights, privileges, and powers of the white colonists. Bermuda would not be home to a black person, free or slave. They could not be English. The developments in the laws regulating black people in Bermuda demonstrate the process of dehumanization and subjugation through the legal system, solidifying the institution of slavery through legislation, proclamations, and court cases, which would continue over the following 170 years or so until emancipation pursuant to the British Slavery Abolition Act of 1833, which took effect in 1834. Okay. Offspring of enslaved people were divided between the slave owners, which we see taking place as early as 1630. Think about that. Only 7 years following our 1623 Act, with the court case of Lewis Ford and the Bermuda Company, dividing the offspring of two enslaved parents belonging to different slaveholders. While the enslaved status of a child followed that of the mother, the place of abode followed contractual agreement between slave masters. All these provisions were put into place to ensure a thriving institution. And note that the court is ruling on a matter within the institution of chattel slavery. Who owns the property? That's the question. Briefly, on the status of children born to enslaved women whose fathers were white men, the Bermuda Company, as early as 1655, ordered that children born to enslaved women would remain property of the Bermuda Company. And in addition, marriage to a white man did not ensure the freedom of the offspring. Initially, blacks did have some civil remedies in the 17th century, despite the inability to defend themselves physically. But in 1670, the Court of Assizes placed, is it Assizes or Assizes? I say Assizes, but I decided to go French and do Assizes. Placed its first limitations of black plaintiffs entering the legal system by requiring them to first go through the counselors of their French local parishes in the 1680s. The court said that the black folks that were suing for their freedom couldn't go straight to court. They had to go through the counselors of their local parishes. In 1687, the House of Assembly stripped black defendants of their automatic right to jury trials in criminal cases. Limitations were placed on the value of the testimony of black witnesses, and then in 1730, the House of Assembly denied the black population the right to a trial by jury. This piece of legislation explicitly stated that black people were not entitled to the rights and privileges of citizenship as Englishmen. Indeed, black people could never be subjects of England. Of note, and if you read the actual words of the statute, it's brutal. And I have it up here if you want to look at it later. Of note, if a black person were to be put to death, it would have to be done by a black executioner, not a white executioner. The paper that I wrote initially, decades ago, for Judge Higginbotham, goes on to discuss the law and its treatment of black people with regard to religion and baptism, together with sexual and personal relations between the races, and what I demonstrated to be the entrenchment of white male domination. I would like to finish this part eventually and update it with more recent research. However, the article published by the University of Pennsylvania is an important discussion of the beginnings of slavery, not just in Bermuda, but for the British Empire. Indeed, Bermuda was part of that network of colonies and colonists. Many of the same people in Bermuda were in Virginia and other parts of the mainland, as well as the Caribbean. I started my first research into this matter when I was at Yale studying for my bachelor's degree in history. I took a class in colonial American history with Professor Edmund Morgan, who proceeded to tell us about the first black people arriving in Virginia in 1619 and how the colonists were not racist. Yeah, I couldn't believe my very young ears. I went about proving him wrong over the following 8 years with a variety of research papers and finally my thesis from Harvard Law School, a part of which would end up being this article that was just published many decades later. I should end with the final point that my article does bring the date for the institutionalization of slavery in North America to 1623. When I first wrote the paper, I didn't quite understand the reality of that assertion. It was our very own professor, Dr. Clarence Maxwell, who would point this out to me years later. Laws are written by men for a purpose always. It is important to know where we came from, to always seek to make things better. Subjugation and oppression did not end with emancipation. It did not end with universal suffrage. And it continues today through whether one has equal access to good education, good health care, a job, the right to love whom you want, and much more. But the beauty of the human spirit means that we do strive to make things better. We have been working since 1834 to overcome the bondage of slavery, which has been a curse on all of us of every color. I only hope that with the work that we investigators do into our past, we will avoid the mistakes of those bygone days as we go forward into a more perfect future. Thank you.